Bank is not there.
Bank is not there.
We are
My
staying
lordship
it.
kindly see the natural.
We are
book
staying
has
it. We are staying.
various facets.
We are staying it. Heard. Mr. S. Dattal, a senior counsel, assisted by Mr.
It does.
Yes.
H. Das, counsel for the petitioner. The case of the petitioner is that in light of a resolution dated 27/6/2024 of the DRT Guwahati Bar Association for adjournment of matters during summer vacation from 1/7/2024 to 12/7/2024, the registrar, Debts Recovery Tribunal, Guwahati, had issued a notice number, page 14, dated 28/6/2024, thereby informing all concerned that all the cases fixed during the aforesaid period from 1/7/2024 to 12/7/2024 in the tribunal would be adjourned. Full stop. However, the sufficient proceedings of the petitioner being SA number 40/2022, IA number 241 of 2022, and IA number 628 of 2023. Give a dash. Dambaru, DAMBARU, DHAR, Das versus Bank of India and another was taken up on 8/7/2024 as the petitioner herein, who is the applicant in the said case, was absent on call, while the matter was adjourned to 18/7/2024 for hearing, the interim order of status quo, granted on 29/2023 was vacated. Next cover. The said order dated 8/7/2024 is assailed by the petitioner in this writ petition filed under Article 226 of the Constitution of India. Next cover. We find that the issue raised in this writ petition relates to a question as to whether the Learned Debts Recovery Tribunal, Guwahati, had committed a judicial impropriety in taking up matters and passing adverse orders against the petitioner, although by a notice dated 28/6/2024, referred above, the proceedings was notified to be adjourned during 1/7/2024 to 12/7/2024. Next, issue notice returnable in 4 weeks. We'll give a fixed date after 4 weeks. So, returnable and so and so. Petitioner shall take steps for service of notice on the respondent by registered post with AD. To stop. In addition, we also permit the learned counsel for the petitioner to serve a copy of the notice and and a copy of the writ petition to the respondent by way of respondent number. Who is at Guwahati?
Both, my lord, from Guwahati.
To the respondent numbers 1 and 2 at by way of Dasi, by routing the process to the registry of the court. And upon service, an affidavit of service shall be filed prior to the immediate of receipt. Next para. As an interim measure, the operation of the order dated 8/7/2024 passed by the Debt Recovery Tribunal, Guwahati, in SA number 40 of 2022, IA number 241 of 2022, and IA number 628 of 2023 is stayed. The effect of this stay would be that the interim order of status quo granted on 29/2023 would stand revived. Next para, list also is
19th of August.
Much obliged.
we were what do you call it? Just because we could not enjoy the vacation, I thought we would dismiss it. Okay.
Lots.
That is a lot. I beg to mention one item for listing. What happened yesterday, the matter was listed. And Lordship has already passed order. The counsel for the petitioner did not inform me. Lordship, his clerk informed my clerk that the matter will be coming on 12th. So I was out of station. I came yesterday. So, but the counsel for the petitioner, they should inform the counsel during vacation period. Lordship. They should inform the counsel for the other side. But they have not informed, but their clerk informed my clerk at 10:45 night yesterday. Day before yesterday, the matter will come on 12th and permission has been granted for 12th of July. Accordingly, I came on yesterday from outside and but when I have come, I saw that the matter was listed and the tender process was stayed, Lordship, because it is regarding the construction of the road, Lordship.
No,
So,
but you get it, you inform the other side and get it listed.
then when the Lordship will on an early date, Lordship, then it will be better for
No,
us.
I can allow for today, but I am not.
But
what do
we
you call
have
it?
to inform the other side today.
No, that's okay.
uh,
But for listing on a regular bench, you have to
Yes.
move the registry, not in the vacation bench, because I am authorized to take up matters in the vacation, not for the.
So, Lordship, I can inform, but whether they are available, I don't know.
That
I
depends on you. If you can bring it, we'll take it up.
Lordship,
Inform the
I'll
other
try
side.
to contact them, then otherwise no way.
You move the
Because-
registry to get it listed.
So, because they should have informed
No,
me.
I understand, but
Vacation
this is.
period, and their clerk told my clerk that matter
No,
will
that's
come on
okay.
12th.
I'm not saying that it's.
Yes, I
no,
should
but-
be given an
but
opportunity,
Today is
Lordship.
only a vacation,
Yes,
so I'm not taking up mentions for the regular.
yes.
You move the
But
registry.
yes, I'll try to contact them, Lordship, if possible, Lordship, then otherwise, what's,
Please.
yes, oblige.
May I please, Your Honor? I beg to mention, I have filed an additional affidavit passed by, order passed by Your Lordship yesterday in connection with WBC number 3508/2024, Your Lordship. So the additional affidavit I have filed as per,
Matter is listed today.
not listed, but you asked to mention in the mention period, Your Lordship. Item number 22 yesterday is settlement matter regarding
Okay.
Lordship. Am I allowed to take the matter? Deeply obliged.
I beg to mention a matter for moving it today, Lordship. Unlisted matter, Lordship had to already passed an order, item number 19 yesterday regarding the APSC, wherein we have been cleared the written test, both the rounds wherein we not initially called for interview. Thereafter, in the first list, we have not been called for interview.
But those, all those will be over by today.
Lordship, now I have 9:30. I have informed the APSC council. He says that today bench is sitting. If I give the information, he will get it today itself.
Okay.
I have also given all the information regarding the candidate.
Daily list, item 1, motion DA.
Regular bail application, my lord. Transited matter, my lord. Already 5 years and 5 months behind the government.
This is NCB. You get your offense, what do you call this?
LCR.
What do you call offense report?
Yes, Lordship.
Bring it on the next date.
My lord, kindly LCR also may be told, my lord. LCR. Because my lord, some witnesses are already examined. My lord.
You could have filed that, the copies of the evidence,
Yes, I have already filed,
then it's not required. If you
File.
file it,
my lord.
you won't require. It's an unnecessary wastage of resources and paper. You have to scan it, send it, we'll have to download it and then take it up. Um, Your name,
H. Ali.
from Mr. Charlie Counsel for the petitioner, and
G. Jane.
G. Jain, the counsel appearing on behalf of Standing Counsel for NCB. Next, the uh, the counsel for the NCB shall be ready with all materials to address the court on the next date of listing. Next para list on 22.
Very good. 22/7/2024. Whatever is required, that offense report, what do you call that?
Offense report.
Offense report. You ready with the materials and offense report to address the court of the next date of hearing. Okay.
Obliged.
Item 2,
May I please, Your Honor? I
Yes.
prefer case diary at this stage, Lord. It's from
From which place?
Bosisto Police Station.
Buses drive. Then 22nd.
Much obliged,
That the case diary be produced on 22/7/2024.
much obliged, much obliged.
By 22/7. Item 3.
May I please, your lordship? Mr. Lordship, application on the political lordship, and in a case is succeeded lordship. There is letter section 6 of the POCSO Act was also added lordship. During the lordship, his incarnation in jail.
Where is the FIR?
FIR lordship. FIR is page lordship 17 lordship. Mr. Chancellor copy lordship. Page 17 lordship. After more than a year lordship, he has been arrested.
Just a moment.
Lordship.
There is a birth certificate of the girl.
Birth certificate has been seized, original birth certificate seized by the police lordship, and there is a report lordship, at page 25 lordship. I have obtained certified copy of that report lordship from the Planet Court below lordship. Page 25 lordship. It's report to section of the.
You were arrested when?
Arrested lordship, forwarding at case lordship 24 lordship. On 27,
Yes, Mr. Gogoi, can we release him?
Now, my lord, search is submitted. The POXO section is there, my lord. Also, notice must, my lord. As per division bench
otherwise.
judgment of our high court.
Only
Let the notice go, my lord. Next that we will consider.
and short date may be given lordship. Yes.
So, heard Mr. J. Abbas, learned counsel for the petitioner, and Mr. B. Gogoi, learned APP for the state. You should notice on respondent
Oh
two,
my God.
returnable on to 8/2024. Petitioner shall take steps within 2 days for service of notice on the respondent two by registered post with AD. Where is the copy of the charge sheet?
Charge lordship.
Page 30.
Lordship. Yes, lordship. Page 30 type copy lordship, and original is lordship, page 36 lordship.
The registry shall call for the scanned copy of the trial court record relating to special within bracket POXO bracket close case number 58 within bracket M bracket close 2024 pending before the Court of Learned Special Judge Bongaigaon. List on 2/8/2024.
Step.
Item 2. Oblige, madam.
My pleasure, your lordship. Lordship will get the affair at page 12, my lord. The petitioner has been arrested on 12/5. It's 60 days, my lord. He is behind the bar.
Where is the FIR?
FRE test page 12, my lord.
কেতিয়া ফাইল কৰিছা কেছটো কেতিয়া ফাইল কৰিছা ডেট অফ ফাইলিং
10th.
10 মিনছ আজি দুদিনৰ আগত
অ।
তুমি অল্ড প্ৰভিজন মতে কৰিছা এইটো ভুল হৈছে তুমি
নহয়, মেইন কপিটো দিয়া গৈছে, এইটো ভুলকে দিয়া
অ
গৈছে।
কাৰেক্ট কৰা নাই
মই কৰিব কৈছিলো ক্লাৰ্কক।
But will still not be inclined to grant you bail.
my lord.
You're a habitual offender, 10 cases against you.
My lord, if your lordship have a look, on the grounds of arrest, my lord, and one of the co-accused has already been granted bail by the learned session judge, my lord.
No, you try your luck there because we'll not be granting. If you habitual
My-
offender,
My lord,
there's not one case, 10 cases.
my lord, kindly have a look, the ground of arrest, my lord.
I have
Page
seen
20
that, that's why, unless I read the down to arrest, I would not have known that there are 10 cases against you.
My lord, the 5 numbers of better is recovered from the scrap MH enterprise. This scrap, the fathers of the petitioner deals with the scrap materials where they found the battery, my lord, that inverter. And the son has been arrested. Why the son has been arrested? The police would know, my lord.
This is known. That's why
No, my lord.
they gave a report.
They have falsely arrested, my lord. The father deals with the scrap materials. He has a shop of scrap material. The father might receive that scrap as a scrap, my lord.
No, father is not an accused.
Yes, my lord. He is not
So
an
therefore,
accused.
the police knows what they are doing. They are not charging the father. Father is having a scrap thing.
Whenever the police searched for that battery, that time he was looking after the shop, my lord. He was there in the shop. That's why the police picked him up that time. He is totally innocent, my lord. And one of the co-accused also have granted bail, my lord.
That's another thing. Somebody may have been granted. I don't follow the
My lord, my lord, my lord,
rule of parity.
my lord.
2007 SCC, though it is there, but I have given my own reasons for not following the rule of parity.
My lord, my lord.
Okay, produce the case diary then. Case diary and let the case diary. Let the case diary and the previous criminal antecedents of the petitioner be produced on, this is from which place?
Mustalpur, my lord.
Baksa.
Baksa district.
Baksa. 24/7. We also need that past criminal antecedents.
My lord. Some recovery was made from
No,
this.
no, I'm not on that.
Yes.
That will come in the case diary. But what we need is the past criminal antecedents of the petitioner.
Yes.
They are saying that there are 10 cases against him. So we need the records of those also. List on. That's all.
Much obliged.
Item 5,
May I please, Lordship?
Yes.
Lordship, this is 59th day, Lordship. And 6 days is the mandatory period.
Where is the FIR?
FIR is page 9.
Has the girl been recovered?
Yes. It is reflected at page 11.
Page 11.
11, the forwarding report. The column of ground of arrest. Number 4 point.
Yes, Mr. Goel, it is in
Yes, the
then.
victim already
59.
recovered.
Okay. Mr. A.K. Sharma and counsel for the petitioner and Mr. B. Goel and lady for the state. The petitioner was arrested on 14/5/2024 in connection with Baihata Sariliye PS case number 129 of 2024 under section 366 IPC has paid for regular bail under section 483 of the BNSS, 2023. Next, the learned AVP has opposed the prayer for bail on the ground that the petitioner had enticed a minor girl, aged about 16 years, and kept her concealed in his house. But Mr. Gogoi, can you find out by a phone call or something, some means as to whether any POXO provisions had been added?
That is not there, my lord. I have also
you-
seen that the girl is 16 years old, my
Yes.
lord, but
Can
that
you-
section is not added, my lord.
No, I understand because subsequent developments are not available here.
No,
Can
today
you get,
it is first day, my lord.
can you get information by phone?
Yes.
Try to take it up at
Yes,
2 o'clock.
yes, yes.
We'll see if, because she's a minor. Because medical is not here. Let him find out if we can get it by 2 o'clock, otherwise
Yes.
see you at that
Obliged.
time.
Obliged.
Item 6.
My opinion.
This much, you can type it out.
This is the regular bail, your lordship. The petitioner was shown arrested, your lordship, and the FIR is at page 23, your lordship.
We'll call for the case diary.
Lordship, considering the detention period, further custodial detention may not be required. Since
We don't
initially
know.
he was arrested on 5/5, lordship, and he has obtained bail from obtained bail, and thereafter he has been shown arrested on 21/5.
No, we don't know, because if he's
And
not arrested, that
in
means there's
that
another
case
crime.
also he has obtained bail, your lordship.
That means there is another crime.
Enforced lordship, similar type of lordship, and the shown arrest lordship kindly peruse the FIR as well as the forwarding report.
No, see, because you see, there.
No whisper
there's
in the
a-
forwarding, nothing has been recovered from my possession,
No, if it's a,
lordship. And it
no,
is
let us see.
lordship,
Fine.
kindly
Not
considering
without
the
case diary.
detention period, your lordship, I may be allowed
Not-
to bail.
Not without case diary here.
Lordship, I am not name accused also, your lordship.
We don't know, that's why we need a case diary.
Lordship. And
Maybe-
no whisper in the FIR forwarding
No,
report
no.
also.
Because this has become a menace.
Lordship,
This type of office has become a menace in the society.
lordship,
You,
I am
while you are in the court, you don't know that your house is broken and things are looted.
lordship, yes, that is right.
That is what is happening here.
Both system, my lord, short date may be given.
Short date, then short date maybe.
Uh, Because nowadays, people say that you lock the house, go out, and when you come back, the house is stolen.
Earlier two cases.
No, I don't know. We read in the newspapers. I don't know personally people
Lordship,
whose house has been broken.
I am
I
agree.
read from the newspapers the amount of house breaking in Guwahati.
Even the police did not
No, it's okay.
take in custody, further custody, lordship.
Case diary on 19th.
19, yes.
That the case diary produced 19/7/2024.
Deeply obliged.
Item 7.
Wait, please, your lordship. The instant petition has been filed impugning the order of the trial court, your lordship, whereby the application filed by the present petitioner was dismissed. The application was filed for seeking.
Why there is an urgency for move it in the vacation court?
Lordship, the next date fixed is on 15th, your lordship,
Okay.
Monday, lordship.
Where is the order?
Order is at page 78, your lordship.
78. Where is the amendment application?
Amendment application, your lordship, I have annexed it. Page 45, lordship.
There is this previous order allowing the tenancy agreements to be bought on record. Where is that?
Lordship, that order is at page 39.
39. Mr. Bhujagoy, we don't find any reason to interfere with the order of the court.
Lordship, what has happened, Your Lordship, the three cell deeds, Your Lordship, which are allowed by the learned trial.
Tenancy agreements.
Lordship, tenancy agreements, which was allowed by the learned trial court to bring on record, Your Lordship. But the said fact was not inserted in the written statement, Your Lordship. And for that reason, Your Lordship, at the later stage, Your Lordship, the interest of the defendant will be frustrated, Your Lordship. For that reason, I have.
No, if there is an agreement, if there is an agreement between the landlord and tenant,
Lordship.
and that has been allowed to be called in the trial court by a previous order,
Lordship.
and that is already on record. So now the witness was examined on that document.
Lordship.
And till that time, you did not take a plea that the documents were not inserted in the written statement.
Lordship.
And thereafter, in the course of trial, you raised the plea that there is no pleading for that document.
Lordship.
And therefore, this amendment application has come.
Lordship.
Now, what is the wrong in the court allowing it?
So there was an inadvertent mistake, Your Lordship, that facts
No,
were not
but you see,
inserted, Your Lordship.
once you permit cross-examination on basis of a document, then to say that the amendment will not be allowed, because you took a plea,
Lordship.
we don't find any reason to interfere. You have any case law on the point?
Your Lordship, there are certain case law, Your Lordship, with effect to that due to the inadvertent mistake, Your Lordship, the amendment can be allowed, Your Lordship, at any stage of the trial. If I may place a Lordship judgment, Your Lordship. Relevant paragraph, Lordship, paragraph 9, Your Lordship.
You are the defendant.
I'm the defendant, Your Lordship.
Mr. Munapai, would you have to explain the due diligence? Because that is what the proviso is added
Lordship.
under Order 617. How do you satisfy the court on that point about due diligence?
I therefore pray, Your Lordship, that at this stage, Your Lordship, the notice may be issued on the next date. I'll satisfy Your Lordship.
No, notice means stay of the proceedings. Because you see, there's this amendment application
Lordship.
is at which page?
39,
39,
Lordship, 45, Your Lordship.
45. Now you see, please try to understand the sequence. You come to this court in 2022,
Lordship.
get an order to allow you to rely on the document, which is the rent agreement,
Lordship.
correct?
Lordship.
And then you then this application is allowed and you are permitted to bring on record 4 rent agreements,
Lordship,
correct?
Lordship.
These 4 rent agreements are, what you call this, annexure B, C, D, E.
Yes, Your
They are allowed to be brought on record. Now you are permitted to cross-examine the witness
Lordship.
on that point. The plaintiff witness was recalled and he was examined on that document. And now it's a stage of your evidence was
DW.
filed or not filed?
It was not, it's not.
It was not filed. So therefore, trial has begun after the issues are framed. Correct. Now, the well-settled law on the point of admission of evidence is that unless there is a pleading on record, the evidence can't be led. So you were aware of this fact when you approached this court earlier in 2022, but it did not amend it. Your written statement was not amended. And therefore, the trial has proceeded. This witness has been cross-examined. The plaintiff witness has been cross-examined. And now you are at a stage when your evidence is required to be filed, you file for an amendment. So proviso to order 6 to 17, how do you overcome that? At best, we can give you time till 2 o'clock to address the court.
Lordship, we have along with the WS, Your Lordship, when the plaintiff have filed their evidence, Your Lordship, they have filed some documents. In the said document, there's a mention about the notice, reply to the notice we have filed, Your Lordship. In the said notice, Your Lordship, the statements regarding to these 3 rent agreements were mentioned.
No, Mr. Pudhaga, everything is okay. But you see, you were aware of the deficiency in the pleadings when you approached this court for the first time in 2022.
Also, there was a mistake, Your Lordship.
But mistake is not a ground to interfere with the order of the court, which is otherwise lawful. We can give you time at best till 2 o'clock to do the research and address the court. Item 8.
But the conduct of a government bank like PNB.
So button up your court first. Mr. Das, button up your court.
I'm so sorry.
Button up your court.
Yes, I'm so sorry. So sorry.
Button up your court.
Oh, I'm so sorry. Please, my lord.
Yes. And
Yes.
Mr. Das,
If I may.
what is the urgency to move a contempt matter in the vacation
My lord,
bench?
yes, the difficulty that I am facing is that the entire auction admittedly has happened as a going concern. So now what is happening, in spite of there being an order of stay, the plant and machinery is being removed, my lord, which I will now show how it is being done, which is a clear, willful and, deliberate defiance of the court order, my lord. And now the entire value of the asset will get diminished. In case today, the actions are not considered, this whole going concern business will get diminished. And tomorrow, now that I have challenged the auction process in itself, tomorrow there's a probability that I might succeed in the auction which is pending before NCLT. So in that case, my lord, there will be nothing for me to since recover. If my lord is pleased to see the order of this honorable court,
Where is it?
at page number 16 it starts.
But there is a proceeding before the NCLT.
Yes. That is the liberty that I had taken because NCLT, my lord, was in summer recess in the month of June. That is the reason on a very limited aspect, we had come before this honorable court. And that is the order dated 25/6/24 at page 16. If my lord permits me to read the order, it
Yes.
starts at page number 17.
You read the operative part.
Yes. The operative portion is at the end.
Para 4 onwards.
Para 4 onwards, I'll read, please. Upon coming to be informed about the auction called for during the process of liquidation being undertaken in terms of the order of NCLT, Guwahati bench, petitioner is aggrieved by the fact that the reserve price is fairly lower than the price offered by the writ petitioner towards one-time settlement. Being aggrieved, he has approached this court as the forum available to him under the provisions of law, namely NCLT Guwahati bench, is stated to be in summer recess and will resume court only from 1st July 24. He submits that as per his instructions, the sale certificate of the auction properties has not been issued, and therefore status quo be directed to be maintained till NCLT passes away orders on applications proposed to be filed by the petitioner. Para 5. Upon such submissions being made by Mr. So-and-so senior counsel, learned DSGI was requested to apprise the court about the status of NCLT Guwahati. It was informed that NCLT Guwahati is indeed in summer recess and will resume court from 1st July 24. However, he submits that in case of any urgent matters, an application can be filed before the registry of NCLT. Mr. So-and-so counsel appearing for the bank submits that the entire liquidation process, including the auction, has been undertaken in terms of the directions of NCLT Guwahati, and the same is as per the parameters indicated in the orders itself. The sale certificates in respect of the auction properties have also been issued, and the amount has already been appropriated to the account of the CD. He submits that under such circumstances, there is no occasion for the writ petitioner to approach this court, more particularly when the appropriate forum is the NCLT and not this court. He therefore submits that the writ petition is unmaintainable and the same should be dismissed in limine. Learned counsel for the parties represented have been heard. This is the finding. The writ petition has been produced. It is seen that the liquidation process is initiated under orders passed by NCLT for any further grievances of the petitioner arising out of or relation to the liquidation process. The appropriate forum is NCLT Guwahati. Although it is submitted by the learned DSGI that in case of any urgency, an application may be filed before registry of NCLT, but there is no clarity as to whether the matters will be taken up by NCLT Guwahati or any other bench during its summer recess on such urgency expressed by the aggrieved parties. Under such circumstances, considering that NCLT Guwahati is the appropriate forum for redressal of the petitioner's grievances, and since it is stated to be closed due to summer recess and will resume again from 1st July 24, without expressing anything on merit, this writ petition is disposed of with the direction that the petitioner will approach the NCLT Guwahati on 1st July 24 when it resumes court after summer recess, and the parties in the writ petition, more particularly the respondent bank as well as the liquidator, will maintain status quo till 3rd of July 24 or till NCLT Guwahati takes up the matter proposed to be filed by the petitioner, whichever is earlier. So on this date, my lord, there is a status quo order on 25th. Then on 26th and 27th, my lord, there is some tracking movement that is happening from in and out of the factory premises. In fact, at page number 43, just to highlight, at page 43, I have annexed a photograph. My lord will see at page 43, this is ML10 C9332. So these tracking movements were happening, and that is what constrained the petitioner through his authorized representative to file a police complaint, which my lord will find at page 21. This is the police complaint that I had filed. 21 is the type copy of the complaint dated 27th itself, 27 June. Yes, so
Yes.
this is a police complaint.
No,
for more.
but thereafter, Mr. Das, you appeared before the NCLT on 2nd,
Yes, ma'am.
and the NCLT did not find any reason to pass any orders, and the matter was adjourned to 18/7.
Only on a very limited aspect, it was considered that sales certificate.
Where is the contempt?
My lord, yes, precisely. My lord, before the learned NCLT, the only reason why it was pushed to another date and now returnable on 18th was because there was a statement from PNB that sales certificate has already been issued. So today, for me to succeed, I have to challenge the entire auction process and eventually succeed for the auction process to be set at naught. But the difficulty is now that, which I am trying to point out, is on 26th, 27th, after having been cognizant of the order of this honorable court, there is a deliberate and willful defiance of the court to the extent that these plant and machineries are being dismantled and removed, which I will prove from the register that has now been recovered. My lord, after the lodging of the police complaint, one official from Bonihat police outpost had gone to the site and the registers have now been recovered. If my lord is pleased to see, I'll just burden regarding the dates, that is 33, at page 33. These are the registers. If my lord will see, the first date is 25/6, that is on the date of passing of the order. There are these movements that is happening. At serial number 6, my lord will see, the name is R.D. Sharma, so-and-so, 9332, at page 33. My lord will have it at serial number 6.
Page
33.
33.
Yes. This is the type copy, my lord. At page 33.
Yes.
All of this was done in great haste, which I want to point out. That on 25/6, at serial number 6, my lord will see R.D. Sharma from Gauripur, so-and-so. This is 9332, the vehicle number, which is coinciding with the photograph that I had annexed at page 43. Then my lord will see page 34. Again, page 35. So these are movements that is all happening. Eventually, it stalled and stopped only after the lodging of the police complaint, only after the official from the PS had visited the factory premises. Interesting, my lord, most interestingly, one Jogeshwar Bora, who was the security in charge of the factory premises of the CD, has been terminated from his services. All because he had participated in that whole physical inspection. So, my lord, all I want to say, just one highlight, my lord, at page 44. This will more or less give the very reason and the urgency which my lord had asked me. At page 44 is the intimation that had come from the liquidator, one Mr. Sandeep Khaitan, at page number 44.
Yes.
This is the email dated 10th of June. So auction happened on 6th of June. This is after 4 days. This is to inform you that in line with the auction notice published on May 10, 24 for sale as a going concern of so-and-so. So entire sale has been affected, my lord, in my most respectful submission as a going concern. Now, my lord is well aware how going concern works. It's a slump sale in order to recover the best value. And now the whole dismantling of the plant machinery and the removal of valuable assets of the CD is only being done so that tomorrow, even if I am in a position to challenge before NCLT and succeed eventually, my lord, I'll be left with nothing but to recover only the things that is left. There was representation on the very first day from the side of PNB before this honorable court.
This the sale is confirmed by the NCLT.
Sale is not yet confirmed. It will eventually be confirmed. By
No,
order
once-
dated
no, no,
25-1.
Once you say a certificate has been issued,
Yes.
certificate will be issued only after confirmation of sale.
So 25-1-2024 is when the liquidation was permitted. Thereafter, the auction had happened couple of times. Even before that auction had happened, no bidders had come. Eventually now, by virtue of this auction notice of 10th of May, the auction was done on 6th of June without 30 days notice period having been expired, which is my ground before NCLT. In great haste, everything is being done. On 10th of June, I get to know that the auction had happened on 6th of June. By the learned liquidator, it was informed that the same has been done as a going concern. My lord, I just put a question to myself. If it has been sold as a going concern, where are these movements happening in and out of the factory in great haste in and around 25th June, in and around 26th June, 27th June? Eventually, it stops on 28th of June when I avail of my legal remedy and approach the Bonnyard police station. NCLT is cognizant of the matter on a different aspect. All I am trying to most earnestly bring before my lord is the defiance of the order of the court.
Mr. Das, we are not still satisfied. The reason will tell you. Then I
Please.
had given a short idea about it earlier. You see what has happened, that this court passed an order making it effective till 3rd. Correct. So before 3rd, you move the NCLT. That is on 2nd, there's an order passed. And there you make a request for to the NCLT for grant of stay, restraining the liquidator from issuing a sale certificate. And that was refused.
It was per se
It was refused
adjourned.
because
Only on one.
court says that there's no necessity of an interim order. Because the court accepted the statement of the lawyer at the bar that the sale certificate has already been issued to the liquidator, by the liquidator to the successful bidder. Now, if you have to, if we have to take cognizance of a contempt, it will be a collateral proceeding, because till date, the sale certificate is not under challenge.
Please, ma'am.
Therefore, the interim order of the court, it stood lapsed on 3rd.
Please.
Before that, on 2nd, you moved the NCLT. So therefore, you can't have a grievance that the order of the High Court is being flouted.
Please.
Because of the fact that subsequently, when you appear before the NCLT, which has jurisdiction, this court, while passing an order, the interim order says that it did not have jurisdiction only because the NCLT was in vacation. Then only the court exercised that limited jurisdiction. Correct.
Please, my
So before that, when you approach the NCLT and the NCLT took cognizance and did not pass an order of stay consciously, that means that the sale certificate was accepted. And once that sale certificate is accepted, you see, I am the owner of this pen. You make a statement that this pen was given by me and your lordship is writing with that. But ultimately, the court refuses to give it to you. I'm
Please.
giving a horrible example, but
Really, of course. Please.
just to make it understand. Now we don't accept that contention. We assert ourselves to be the owner of the this pen. Now to remove this pen from this table to this side of the table would not be a contempt or what you call disturbance of the ownership of the property. Correct. My example is a horrible example, but it's only I'm structuring it so that it's easier for understanding.
My lord, the pen is being transferred from A to B
No,
in the
it's
form
not
of the
like
pen.
that.
But in the moment I take the cap out and sell the pen, the value will diminish. I'm also just drawing analysis
No,
from the same
because you see, once there
example.
is a sales certificate and then the sales certificate, you see, when there is a sales certificate issued, there is a presumption that the assets of the industry has been documented, and the sales certificate is issued, which includes all the plant and machinery. Now, supposing the 75% of the plant and machinery are dismantled, still you have the asset value left, which can be still recovered. So
But
you see, the
please.
contempt must be willful disobedience. When the post facto the NCLT refused to give you a interim order, that means that the ownership of the person of the property, which is covered by the sales certificate, is accepted.
Please, madam, I'm so
Then where is the
obliged.
contempt?
I'm so obliged that my lord has pointed out this issue. My lord, today, for me to eventually succeed, I'll have to prove on merits how the auction is bad in law. That portion of the matter, including the issue of sales certificate, will eventually be decided by NCLT Guwahati bench. I so humbly, accept that position. But when there was an order of status quo on 25/6 passed by this honorable court, I just put a question to myself. Where was the haste to have removed the plant machinery on 26, 27, 28, all in defiance of court order, which I will not be able to really bring about as contempt action before NCLT. For that aspect of the matter, my lord, with my limited understanding, this is the only court.
What is the date of this sales certificate?
My lord, there's a very, very vague statement that has been made with due respect to the learned counsel before NCLT as well as before this court. My lord will see page 47. Page 47. This is the last 3 lines I'll just burden the court with. Upon specific query from the bench, the learned counsel appearing for R123, Mr. So-and-so made a statement across the bar that the sale certificate has already issued by the liquidator to the successful bidder who has paid the entire sale consideration. Just a statement was made at bar, which I will eventually challenge. My lord, today the fear is not of the turning around of the sale certificate if I eventually succeed on merits. I am only on a very limited aspect that when there was status quo order, my lord, today as a going concern, the entire assets of the CD is being sold in auction. This whole removal of plant and machinery, my lord will see the registers once at page 33. I'm so sorry, I'm burdening the court.
No, it's okay. We've seen that.
Yes, at page 33. So I will just show, my lord. It starts at annexure 3, collie, page 27. At page 27. My lord has it.
Yes.
This is type copy. 12/6/24. There are 5 entries. 22/6. No movements for 10 days. Even after having the auction been confirmed on 6/6. Then 23, there is some movement. Main movements happen when I do an advance service on 24 in relation to the writ petition that I had filed. my lord will see 24th, 25th, 26th. In great hurry, and in great haste, all of these movements are happening. From 6th of June, when the sale was done, and thereafter, allegedly, the sale certificate has since been issued, my lord. There is no movement happening. Only when I do an advance service in relation to the writ petition, assailing the auction process, there is a movement. So I am only trying to establish a very, very small aspect of the matter, that there is a status quo order of this court. In spite of the status quo order and being cognizant of the order, my lord, there is intentional removal of the plant machinery, which I think should be put before them only for the sake of clarification. Otherwise, tomorrow, my lord, this aspect of the matter, I'll not be able to prove before NCLT. That is the only limited issue. Otherwise, I'm so obliged that my lord has, in fact, guided me how to pursue eventually for NCLT is the right forum. I'm so obliged.
Okay, let me examine Mr. Das.
Please,
See if at all we can issue a notice.
please, my lord.
Let me examine.
Well, just because eventually, my lord, this whole issue of going concern, my lord is very well aware how it works. A slum sale is done to get the highest value. Tomorrow, my lord, assuming I succeed on merits and I am able to put the entire auction at naught, my lord, nothing will remain in my situation. And I am just worried that, official of a government bank, I don't want to say much, in great haste, all of this is being done on 24, 25, 26.
That's the aspect we'll have to examine. You
Please.
see, Mr. Das, the issue would be otherwise. That's why I gave that example of that pen. You see, the restrainment order is on the authorized officer. Correct?
Please.
Is on the authorized officer. But if the authorized officer has already issued a sale certificate, then the ownership transfers from the authorized officer to the purchaser. So he's not under restraint from removing the assets. That is the issue.
But there is not so much clarity right now.
No,
In my most
that's why-
respectful submission regarding the exact date of issuance of sale certificate,
That's
a
what we'll
statement
examine.
was given at bar.
That's what we'll examine. Okay, I'll pass orders in the chambers.
Yes,
And Mr. Das, how are you? It's a long time seeing
Yes.
you after many years.
yes, your worship.
How's
Very-
everything?
Thank you so much for asking.
How's everything?
Everything is fine. I'm so obliged.
You're here you're here for the time being? No.
No, I'll just come for the hearing, my lord. I'll leave today.
Okay.
In case my lord wants to put a short date, I'll try to satisfy my lord on this issue next week. If it can be taken up on 17th or 18th, I'm physically here.
17th.
17th, 18th. I'm physically here, my lord. Only to assist the court.
Okay, then that will be better.
Please, my lord. I'll make an endeavor to assist the court.
Okay. But Mr. N. Das, then counsel for the petitioner. The court takes note of the contents of the order dated 2/7/2024 passed by the NCLT, Guwahati bench in IA within bracket IBC bracket close oblique 124. You'll find that at page 45, like there are two numbers, so and so in CP so and so, that a sale certificate has already been issued by the liquidator to the successful bidder who has paid the entire sale consideration. Full stop. According to the query of the court is that whether the petitioner is aware of the date on which the sale certificate was issued. And secondly, on issuance of sale certificate, if the ownership of the assets covered thereby is transferred, would the respondents be still liable? Whether any case of contempt is made out against the respondents. Full stop. Next, accordingly, the counsel of the petitioner place for is granted uh, time to address the court list on 17/7/2024.
Obliged.
But glad to see you. I'm really happy to see you.
I'm so obliged, man.
Item 9,
May it please your lordship. The previous bill application. FIR is page 9, my lord. The manifest is 10.
Just a moment. That yes, Mr. Uddin.
You, my lord, before reading FIR, my lord, just 1 minute, my lord, the background of the
Yes,
case. The present petitioner is a my lord, railway's laborman. And near his house, my lord, a bridge was repaired by the government, my lord, and some disposal item, my lord, iron joist, steel joist, and some wooden was kept since long days, my lord. And on the day of LS incident, my lord, the one person came to the place of that lying that joist, my lord, and he introduced the present petitioner, his official authority, and he wanted to shift the disposal item to another place, my lord. Accordingly, approached the present petitioner, being a labor.
Mr. Uddin will still require the case diary.
And my lord,
Because of the
already
fact that
six, my lord.
it's a government property, and then the allegation is that by forging the seal of the executive engineer PWD, the items were removed.
Yes, ma'am.
So whether you are a laborer or not, we don't know.
That person, my lord, when came, my lord, he showed it in his WhatsApp, my lord. There is a order. That person, my
No,
lord.
we are not saying that you are.
So I am only praying the interim, my lord, that he will appear before the police, my lord, and he will
No,
cooperate the
no.
WhatsApp order,
No.
and my lord,
When
the
there is a
person
forgery
also
of
send the money also.
No, when there is a forgery of the government PWD executive engineer to remove the PWD assets,
lord,
we can't give you a
If he can, my lord, appear before the police, my lord, it
No,
will
no,
be
no.
easy to complete the investigation.
No.
Because already I have mentioned the name that person.
No.
But since I could not, my lord, go to the police, my
Not
lord,
without case diary, Mr. Uddin.
the actual fact, my lord, I could not explain. There is a problem. Because that person, my lord, sent the money also in my account, my lord, for the labor charge, my lord. That
No,
account
that's-
also may be examined, my lord. And WhatsApp, my lord, in whose WhatsApp the order has been sent to me. This is the order.
Not when there is a
That also,
forgery
my
of
lord, he
government
can
officer.
show.
No, not when there is a forgery. Let the case diary be produced from, this is from which place, Mr.
Welfare
Uddin?
district.
Golpara district, Mornoy, man.
Huh?
District Golpara, PS Mornoy.
22nd,
Yes.
22, 7/2024.
I'm honest.
Item 10.
FIR page 9.
Where is the FIR?
At page 9.
Have the case diary.
No, shape one thing. Okay. Here it is mentioned that girl is 16 years. I have annexed the birth certificate of the girl. She says it about 17 and a half years. And the boy, he is 18 and a half years.
No, that's okay. Once it's below 18,
Yes.
then we'll have to understand whether what type of case has been subsequently found out.
Worship and the other two persons worship. One is
After the medical, what sort of case has been made out? Let us see.
this is exactly except lordship accused number 1 lordship 2 and 3 maybe lordship.
Not to the, but we can give it to Mr. Gogoi. We can
Lordship.
give it to the petitioner number 3.
Yes, that is
72 years.
72 years is shown.
Give him the-
Interim.
Heard Mr. A.Z. Ahmed, counsel for the petitioners, and Mr. B. Gogoi and the APP for the state. That the case diary be produced on when this is which place?
South Salmara.
South Salmara. Twenty-fourth,
Yes.
on 24th, 7/2024. Next one. The petitioners apprehend arrest in connection with South Salmara PS case number 1 to 9 of 2024 under section 363 of 368 IPC. And accordingly, the petitioners have paid for pre-arrest bail under section 438 CRPC. Now 482 of BNSS on 2023. The period for interim bail is opposed by the APP on the ground that the minor girl of the informant has been enticed away. And therefore he submits that perusal of the case diary would be required. Full stop. Having observed that the petitioner number 3 is projected to be a person of 72 years of age. The court is inclined to grant interim pre-arrest bail to the petitioner number 3, namely Fozur Ali, Fozur Ali, by providing that in the event of his arrest in connection with South Salmara PS case number 1 to 9 of 2024, petitioner number 3 shall be released on interim bail on furnishing a bail bond of rupees 20,000 with one surety of like amount to the satisfaction of the arresting officer. Interim bail to the petitioner number 3 is granted on the following conditions. Appears to the IO within 7 days from the date of the order. List on
24/7.
24/7. His diary.
Item 11.
For production, his diary. 11. Yes, Mr. Ahmed.
FIR Lottery will find page 17. Here 3 petitioners are there. Petitioner number 2 is the son of petitioner number 1 and 3. And the main accused is accused number 1. The deceased was his second wife, and the FIR was lodged, alleging that after 15 years of marriage, there was some dispute, and accordingly, at the instigation of accused number 6 and 7,
You still have to look at the case diary.
just one
It's a
thing is
case
trying to
of-
point out, Lordship may kindly see page 18. The petitioner number 2 and 3 were at Guwahati for their medical treatment. There are documents I have enclosed, page 18 onwards, your Lordship will find. And petitioner number 1, who is a government employee, Lordship, I have enclosed his identity card at page 12. They are residing separately. That is my Lordship. May also may kindly note one thing, that the village is mentioned as Sadullah Bari, and in the I-card, your Lordship will find they are resident of Tangon Part 1. I have
Which page?
Page 12 I-card. Yangon Part 1. And I have also stated in my petition that they are residing separately, which is about 4 kilometers distance. Lordship. 2 kilometers.
Item 5 to মানে শেষ হলে মাতি দিম ন?
And on the alleged night, the petition number 2 and 3 arrived at their house at about 3:30 a.m. Lordship. It takes about 7-8 hours from Guwahati, Lordship. Until 5-6 Lordship, p.m. they were attending the doctor.
No, you see the lady who died, I think she is the wife of petitioner number 1.
No, accused number 1. Petitioner number 1 is the brother of that accused number 1. That page 17 Lordship will say Shahadat Ali. He is already arrested. And even his first wife, that is accused number 6. Wife of
Where is the FIR? Where is
page
the FIR?
17. Page 17 Lordship may kindly see. Two brothers, that is accused number 1 is the prime accused. Accused number 2 is the petitioner before Lordship, who is brother of accused number 1. Then his 2 sons are mentioned, 3 and 4, that accused number 1 son.
বিনয়
Then Monwar Hussain, petitioner number 2, son of petitioner number 1. Accused number 6 is Mofida Khatun, first wife of accused number 1. And accused number 7 is wife of accused number 2, that is petitioner number 3. All the members of both families are named here. And even accused number 3, who is son of accused number 1, he was also arrested, but due to his examinations, he was granted interim bail by the court below. That forwarding report I have enclosed. The prime accused is already arrested. Page annexure 4, page 27.
আমরা আইটেম 5 সরি 5 তো মানে লিস্ট কোন শেষ করে মাতি দিছে মিটি দুটা
Mr. Boshu will give the interim protection to petitioner number 1 then. He is a head teacher.
রঙা ফেল গিয়ে
And 2 and 3 were at Guwahati. That page 8.
2 and 3 we are not protecting, but protect number 1. Heard. Mr. A. Ahmed, and counsel for the petitioners, and Mr. K. Boshu, runner APP for the state. Petitioners were pending arrest in connection with Mankachar PS case number 139 of 2024 under sections 120B 302 34 IPC, corresponding to GR case number 306 of 2024. File this application under section 482 of the BNSS 2023 of PRS bail. That's why the case diary we produced on when
What's it, 31st?
it will be too long because we are not giving interim protection to 2 and 3.
Yes, Lordship. In the Lordship 24th.
22. 24. When-
24th, Lordship. Month.
Okay. 24, that's right. Full stop. The next paragraph, the runner APPS opposed the prayer for interim bail. The petitioners on the ground that the victim lady was strangulated and killed. And thereafter, the dead body of the victim was thrown in the veranda of the house. Veranda of the house of accused number 1. Next paragraph. Having seen the projection by the petitioners that the petitioner number 1 is the brother of the prime accused, but he's the head teacher of
Boisawari LPC.
2230 number. Spelling is BAISHABARI. LP school. And the court is inclined to grant in the bail to the petitioner number one, namely Kosom KOSOM Ali, that in the event of arrest of the petitioner number one in connection with Mankachar PS case number 139 of 2024, corresponding to GR number 306 of 2024, and shall be released on interim bail on furnishing a bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting officer. Interim bail is granted on the following conditions. Appearing to be within 7 days. This constituency.
Yes, for the petitioner number 3, there is only that the
No,
e-advice of
not,
petitioner.
we are not giving protection to her.
Obliged.
We'll take a break and come back.
চাৰিটা ছাৰে এটা দুটাত ফিক্স হৈছে এইটো কাৰণে দিগদাৰ হৈছে ग्रीन देने के लिए मना किया था इसलिए तो मना किया था तो इन्हें ऐसे कागज बर्बाद करेगा ठीक है आप रखिए मैं देख लूंगा ना मैंने आपको मुझको पता था जो 18 देगा ना एकदम इंसिल हो Item 12.
Abatement, item number 5, Lordship. If instruction.
That item was fixed at 2, my lord. We have instruction, my lord. Charge sheet already submitted and POXO edit, my lord, in this case.
I may be allowed to.
Item 5. But Mr. Gogoi, that was very fast.
It's
Good.
received.
At the outset, Mr. B.V. Goel and an APP has submitted that as per instructions received by him, a charge sheet has already been submitted in this matter with added with addition of offense committed by the petitioner under section
POXO 4.
section 4 of the POXO Act. Full stop. Next para, on such information being provided, Mr. A.K. Sharma and counsel for the petitioner seeks to withdraw this petition and to move the jurisdictional court. Full stop. There is allowed. Matter since dismissed. On withdrawal as indicated above.
Triply obliged.
12.
May I plead it?
Yes.
Lordship, 482 application number, the FR is page 16.
Page.
Page 16.
But then we can't grant you interim bail without case diary.
Lordship. Lordship, I'm not naming the FR. The subject of the FR itself shows the allegation against one, Bornil Buragohai. I am the ranch officer presently working in the Dumduma ranch office, my lord. And once upon a time, that is since 2021 February till 31st July 2023, I was in the ranch office of Sunari. That is why maybe.
Where is that statement?
Lordship.
Where is that statement?
Lordship, there is little mistake in typo in the year so far as page number 5, paragraph 8. But it was second paragraph, my lord, on 15 to 2023. It is actually 21. It is a error in so far as year is concerned. By mistake, it was written as 23, but it is 21.
But this happening is within that period only.
Lordship, that period, lordship. I'm
Because
joined my lordship in Dunduman. The Annexer 18 is the identity card, and in fact, the name accused Bornil Buragohai has already granted interim protection by this honorable court. This is the page number 19, the order. I'm no way connected, my lord. Signature was forced. Allegation is that signature was forced by Bornil Buragohai, and signature is the DFO signature, my lord. I am the ranch officer. My name is no way connected, my lord.
But you're the DFO, you're,
I am not DFO, my lord. I am the ranch officer. DFO, DFO forging signature of Sri Deven Chakraborty.
where is your I card?
Lordship, page number 18.
Mr. Boshe, then extend the interim protection to the
Yes,
petitioner.
Lord, the prime accused is already under interim protection.
Heard SP Barada and counsel for the petitioner and Mr. K. Boshul and the APP for the state. Petitioner who is apprehending arrest in connection with Sonali PS page 1 was paid for PRS bill under section 482 of the BNSS, 2023. That's why let the case diary be produced on when
Also 31st. 31st of July.
case diary or scanned copy thereof be produced on 31/7/2024. Next. Prayer for interim bail is opposed by the landed APP. However, on consideration that the petitioner has posited in this bail application that he is the range forest officer and that the allegation in the FIR is that the signature of the concerned DFO was forged. What is inclined to grant interim pre-arrest bail to the petitioner, namely so and so, providing that in the event of his arrest in connection with Sonali PS case number so and so, he shall be released on bail on furnishing bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting officer. To stop. The interim bail is granted to the petitioner on the following conditions. So the day before the IO within a period of 1 week from the date of the order. List on 31/7. Item 13.
May I please, your lordship? FIR is page 9.
Page 9. We'll call for the case diary because POXO is added here.
Yes. Noted.
Call for the case diary. Let the case diary be produced on. This is from which place?
Lordship, it is Gwalpara.
Gwalpara.
And
It takes some time. 24/7/2024. Case diary or scan copy thereof.
notice to respondent number 2.
Huh?
Notice to respondent number 2, Lordship.
Oh, actually, this POXO.
In-
yes,
informal
yes,
cause.
yes. So in the meanwhile, next para, in the meanwhile, the petitioner shall take steps for service of notice on respondent number 2 by registered post with AD, which is made returnable on. Then it will not come by 24. Twenty-six, 26/7/2024. Next, the petitioner is, learned counsel for the petitioner is permitted to collect the postal receipt number and to submit postal track report prior to the next date of listing. Oh, sure, this is criminal matter. No, not that. The service can be done through you, through the registry police station.
Yes, Lordship.
We say that you should take steps within 2 days for service of notice and respondent to. Post of the return of notices shall be processed by the registry and handed over to the, to Mr. K. Vashal under the APP. For-
Office of the Public Prosecutor.
Acha, to the office of the, Public Prosecutor Assam at Guwahati High Court. For service being affected through the, to the respondent through the jurisdictional police station. Stop. The service report shall be produced on the next date of listing. List on 26/7/2024. 14.
Very applicable, Lordship. Madam, regarding settlement of market, my lord.
Yes.
My lord, Borvata Ancillary Concept issue NIT, my lord, 30th June, my lord. May, my lord. The NIT was open, my lord, 21st June, my lord. Accordingly, my lord, CS was prepared, my lord. In this said CS, my lord, my name is, the petitioner name was appeared at serial number 1, my lord, valid highest bidder, my lord. In the meantime, my lord, the respondent number 7, his name appeared in the comparative statement, my lord, serial number 26. His with value, my lord, more than 5 lakhs, my lord. He was allowed to run the market, my lord. This is my case, my lord. My prayer is very simple, my lord. Give a direction to complete the settlement process within a short period, my lord. As for CS, my lord.
But your rates are unrealistic. You are Abdul Rafiq. For a tender of 3 lakh rupees, you are quoting 27 lakh.
My lord.
Have you given an undertaking that you will not ask for refund from the government? Is there any statement in the rate petition that you will not ask for any refund from the government? Unrealistic the bids can't be accepted. They are rightly rejected your bid. For a market of 3 lakh rupees, you are quoting 27 lakh.
My lord, my lord.
The predatory market, predatory, what you call bidding, you have a restriction clause.
May I submit one?
Huh.
My lord, on 29/6/2024, one notification was already there, my lord, from the government cancelling all the tenders, my lord. That is why earlier lessee was continuing. In that yesterday's matter, my lord, today they have mentioned that matter, my lord, that notification for the whole state, my lord.
I forgot the context.
The government decided, my lord, after going through a cabinet decision, my lord, one notification has been issued.
Yes, I remember now.
As
Yes.
per that notification, earlier all tenders, my lord, we have cancelled and we are going for new settlement as per new NIT. And
Okay.
he was that private respondent, my lord, he was the earlier lessee, and as per that notification,
No,
now
but
he
this,
is.
no, but this page 15 is a new tender.
Yes, that was already cancelled on 29 by
Okay.
notification. That notification, my lord, I had one another petition, they have annexed, my lord. And in this petition, that was not challenged, my lord.
Yes, you are Mr. Khan.
My lord, R.Ali, my lord.
Huh?
R.Ali, my lord.
Ali.
My lord.
Mr. Ali,
My lord.
in view of this notification, you are aware of this notification of 29/6?
No, my lord, no, my lord. No, my
You
lord.
look at
That,
it because
my lord, in that notification, my lord, nothing was mentioned, my lord, as per his statement, my lord. Only cancel when they issue fresh. Nothing is mentioned
They-
there, my lord.
maybe they have not gone to the school where you
My
studied.
lord, my lord. My lord.
We can't
My
say
lord, then
that.
give a direction to take further step, immediate step. for new fresh
You will do
NIT.
it
My
because
lord.
this is cancelled. Now, what do you do with this, when all the tenders are cancelled?
My lord, only cancel, my lord, earlier lessee will enjoying,
Yes,
my lord. How long, my lord?
so you'll have to challenge it.
My lord, my
You'll have to challenge that.
lord, my lord.
For how long is a question you are asking the court, we have no answer,
My lord, my lord.
because I did not do that. Extension order is not by the court, so we don't know till when.
And the whole process is
Correct.
complete, my lord.
No, I understand, but can't you help,
Government
it's
is
a
doing, my
cabinet
lord,
In the
decision.
meantime, my lord.
control the
Cabinet
price of the things, my lord.
It's a
That is
cabinet
the-
decision.
Now, my lord, in that cabinet decision, my lord, there it is mentioned, my lord, further fresh NIT when issue,
Yes,
nothing
yes.
there.
Yes, yes. It is there, but when the cabinet will not take a decision when? They will take a decision, do it. When to do it is not the decision. Look at this.
Yes.
Mr. R. Ali, the counsel for the petitioner. Stop, Mr. S. Datta Lanet, standing counsel for PNRD. And RD, huh? PNRD has submitted at the outset that by a notification issued on 29/6/2024, which is pursuant to a cabinet decision taken on
27/6/24.
27/6/2024, all the tenders of the PNRD department was cancelled, and decision was taken for re-tendering.
Right.
Full stop. Next para. Accordingly, it is submitted that the tender which is in reference in this writ petition was also cancelled. Full stop. Accordingly, the matter stands adjourned today to enable the learned counsel for the petitioner to take instructions and take appropriate steps listed in the motion column on 22/7/2024. Item 15.
Obliged.
May please, Your Lordship.
Yes, Mr.
The petitioner, she is working as a supervisor, my lord, in the office of the CDPO in West Karbi Anglong. Now she has been sought to be transferred to other place, my lord, Salem. So, no, not at that transfer order, my lord, will find at page 30. Transfer order, my lord, at page 30. The second one.
Yes.
This has been passed, my lord, without considering the office memorandum, my lord, that I have placed in page 32. What it says, my lord, at serial number 3. Page 32 at serial number 3. Transfer orders should on normal occasions be effected in such a manner that the academic session of the children of the transferred employee.
No, but you see, Mr. Munir, the situation was different here. We had elections. So therefore, during the election period, no transfer could have taken place.
Right.
Now the annual transfer will take place only after the elections are over. So now that has been effected. How can we find fault with that?
There is another office memorandum, my lord. At page 35, we have placed it. Serial number 3, my lord, page 35.
Just a moment.
My lord.
Have you informed?
Yes, my lord, copy has been
Standing
served. Yes.
No, copy served is different, but are they aware that the matter is listed today?
So we, it was informed that we are going to make a mention today, yesterday.
No, there's difficulty because
At third file, my lord, you'll find the notice.
no, you see, it's not good to notice. You try to find out, you know everyone. Try to find out.
We contacted my lord, he is not in the court today.
You see, this is not good to notice that the matter will be listed in the vacation court.
Notice is here, my lord.
No, but the matter is being listed in the vacation court is not there.
We informed him, my lord, that we are making a mention to this.
Because this is vacation, if they are not aware of the listing. It was very difficult.
Oh, my lord. With regard to the second office memorandum, may I place it before your lordship?
Huh?
May I place the other office memorandum before your court, before this court?
No, but transfer if this, if the other side is not there.
Now, my lord, she have to join on 15th, my lord. Page 35, my lord, may I place this last one, my lord? Page 35.
You see, Mr. Munir, this SC Saxena, it says that even if there is a policy, aberration of the policy is even not a ground to interfere with the transfer order. And what is the difficulty you will be facing?
My lord, the children, they are studying in school, my lord, and the husband, my lord, I have annexed his joining report, my lord, as well. He is working as a headmaster, my lord, in his school, ME school, which is, my lord, 300 kilometers away from their regular place of residence, my lord. So, my lord, now if she have to go, my lord, and she is also a person with disability. That certificate also we have annexed, my lord. Now she have to travel all around, my lord, around 7 hours journey to attend her office, my lord. That is approximately 300 kilometers, my lord. She have to travel all along, and she is a person with physical disability, my lord. That certificate is also annexed, my lord. Page 23, my lord. And her children, my lord, 2 children, my lord. One is studying in class 6, my lord, page 25, and other is studying in class 2. That is from page 27. So minor children, my lord, their academic session will be interrupted if she has to go and stay in the other place, my lord.
Try to give them a message, we'll take it up at 2. Try to give them a message that the matter is being taken up at 2 o'clock. Take it up at 2.
I'll
Try to
inform.
give them a message. Yes, item 16.
Item 16.
The disqualification is in file, my lord. You're saying selling my disqualification. My lord, response to a my lord bid against my lord request for proposal for my lord statutory audit of Assam Rural Livelihood Mission for 23-24, my lord. It was
Yes.
2 bid system, tactical and financial bid. I was qualified in both the bids, my lord. Thereafter, my lord, the total floor price was 16 lakhs, my lord. There is no indication in the bid document, no here, my lord, that
What?
it should be bifurcated into 2, my lord. That the consultancy fees as well as the post-OD service fees, my lord. That my
Pardon me, consultancy fees and
and my lord, the post-OD service fees. There is no such indication in the bid document anywhere, my lord. But while my lord uploading, my lord,
consultation fees and
And my lord, post audit service charges, they call me.
post audit,
PAS, post audit service,
audit service.
service.
Under the Service Tax Act, how they are, uh, how they are placed in the Service Tax Act, there are difference of rates of service tax.
My lord,
On-
8% on the total,
Huh?
8% of the total fees amount of.
There's no separate,
18%.
there's no separate service tax on consultation fees and audit service.
My lord, they, on the total fees, whatever is there, they charge 18% GST. My lord.
No. You see, once it is a service,
Ah.
there will be a service tax component. GST is different. GST is on the billing of, now service tax, huh?
Now
GST, GST, huh?
Yes, sir.
So GST is the rate same or different rates in these two components?
Yes, my 18% they are charging, my lord.
18%.
18%, my lord.
Okay,
Yes,
so
yes.
one charge only.
Yes, one charge. One
Okay.
charge. The com- 18%. So now,
Just a moment.
lost.
Where is your bid document?
Huh? It's para 2, my lord, my writ petition lordship. That's stated. Lordship will see. No,
Now, please come to page 79.
lordship.
This 79 has two cost components. One is under the heading of remuneration and another is any other cost.
Cost of financial proposal, remuneration.
One is remuneration. So consultation fees becomes a remuneration.
Yes, my.
And post audit service.
Yes, my lord.
Is there any clarity what is a
No,
post?
no, my lord.
No,
There's
no.
clarity.
No,
Yes,
this,
sir.
my question is not that. The question is, what is post audit service?
Post audit service, no, it is clarified in the bid document. In fact, in your complaint, my lord, which I lost before them, we have stated that, if your lordship look into page, my lord, RPF, my lord, request for proposal, that my lord will find it pays 60? 67, lordship, of the bid document, my lord, page 67.
67.
Yes, my lord. Developer partner. Developer partner হয়ে যাবে। Page 67 of Inter.
Page 67.
Yes, my lord. Page 89, my lord. Actually, internal page 67 or page 889.
89.
Page 89, lordship. Cross 12, alone is the consultation fees, consultancy fees, my lord. That is what is mentioned in the bid document. Minimum consultancy for the entire assignment. So, cost will be 16 lakh, my.
Yes, Mr. Datta, there is no bifurcation in the tender document. Why you should not state?
I have to take instruction.
Hmm?
I have to take instruction.
You don't finalize the tender till next date. When do you want the matter to be listed, Mr. Datta?
My lord, 1 week.
1 week. Okay. For Mr. B.J. Ghosh, learning counsel for the petitioner, and Mr. S. Datta and APP for the, learned standing counsel for the
PNR
respond,
One and two.
PNRD. PNRD department representing respondent number 1.
1 and 2 also I
Two.
will payment.
1 and 2. Next one. Where is the communication to you? Are you
My lord,
rejecting it?
communication to me, lordship will find at page, my lord, is 203, my lord,
203.
my lord. Page 203, that is the disqualification. It is on, my lord, 28/6/2004, uploaded in their government portal. Visible on 28, page 203, disqualified.
203.
My lord, annexure 9, lordship.
203.
Reason for disqualification is not there in Annexure 9, my lord. This is only a screenshot of the website.
Page 2. Yes. 197 page, we are L1. Then for you, I will to reply to the queries.
My lord, page number 206, my lord. This is the representation submitted by the petitioner, my lord. And as per this, my lord, we have come to the notice that our financial bid has been disqualified on the ground that our financial quote was lesser than the minimum floor price mentioned in the tender document.
That is subject to challenge. I thought
Yes,
page
yes.
197, it is not less, my. Floor price is 16 lakhs. And accordingly, we have declared L1 on basis of that.
But then something is missing somewhere. You see, come to page 200.
Lordship.
In 200, you say that when you uploaded
Yes, yes.
16 lakh rupees, then they say that you bifurcate. Then you bifurcated, you said that since zero was not being accepted,
Yes.
you bifurcated. Now, that means you were, when you were
Because,
uploading
my
the
lord,
tender,
total-
you were aware
in
of
my
the,
humble subject to your lordship's correction, because total floor price was 16 lakhs, my lord. When we uploaded it, it was not accepting because the website, they are indicating that it should be bifurcated. So within the minimum, inclusive of that 16 lakh, my lord, we bifurcate it, my lord.
But then where is that floor, minimum floor price? Where do we get it?
My lord will find it, that is page 16. Page 87, lordship. Lordship will kindly say. Of the bid document. Yes, my lord. Page 89, sorry. 89, my lord. Clause 12.
Yes.
That is 12, my lord. Minimum consultancy fees for the entire assignment. There is no bifurcation as such mentioned. It should divide into this and this, my lord.
Uh, but in case of the petitioner, is that in the what is this called? Invitation to bid.
Yes, my lord. Request for proposal. lordship.
In the request for proposal within bracket RFP
RFP.
for short. Comma, specifically in clause 12 at page 67 of the tender document. Comma, the consultancy fees, the minimum consultancy fees for the entire assignment, excluding reimbursable cost, would be rupees 16 lakh. Full stop. It is projected that the RFP did not envisage any bifurcation of the consultancy fees. Full stop. However, comma, when the financial bid was uploaded, comma, the portal was not accepting a consolidated bid and required a bifurcation. Stop. It is submitted by the learned counsel for the petitioner that as the portal was not accepting 0 as post-audit service, comma, the petitioner had bifurcated the consultancy fees into 2 heads of consultancy fees and post-audit service within the range of 16 lakh rupees. Full stop. On the ground that full stop. Next para. On the ground that the consultancy fees fell below the benchmark of rupees 16 lakh, comma, it is projected that the bid of the petitioner was held to have been disqualified. Full stop. Accordingly, the disqualification of the petitioner in submitting the financial bid is assailed in this writ petition filed under Article 226 of the Constitution of India on the ground that otherwise the bid of the petitioner was L1. Next, issue notice returnable on.
My lord, as the private respondent is already also there, my lord, they make it lordship 2 weeks, my lord, 2 weeks. My lord.
Okay. Returnable on 26/7/2024. We make it 29 because the 3 days will be taken in steps. 29/7/2024. The petitioner shall take steps within. You have to take in course of the day.
Yes.
Take steps in course of the day for service of notice on the respondents.
Oh.
Number 3.
Lordship may allow us to take by Monday, my lord, because we have to get it from branches, because If your lordship, it's up to my lord. I'm just making a prayer for lordship.
No, because otherwise it will take 3 days for the court to,
Clerks are also not
no, because 3 days would be, you will not get service report then. Or you can sub by Dasti, they are at Guwahati only.
Yes, my lord, that we can.
Ah.
Yes, yes. That,
Okay. Steps within, steps within 15/7/2024. In addition to postal steps, the petitioner shall also serve notice on responsibility by way of Dasti by routing the process through the registry of the court and upon service. An affidavit of service shall be filed prior to the next date of listing. Next paragraph. Notwithstanding that the learned standing counsel for the respondent numbers 1 and 2 has opposed the prayer for interim relief, but as it has been projected that in the request for, in the RFP, there is no indication of bifurcation of the minimum minimum consultancy fees as an interim measure until the next interim measure until the next written ruling is provided that the respondents the respondent numbers 1 and 2 shall not finalize the tender for tender for consulting services for appointment of statutory auditor for conducting statutory audit of ASRLMS for financial year 2023-24. Audit report is required to be submitted when, by when?
By my lord.
No,
3
no.
months, so 3 months. 3 months and 29 days, my lord. 3 months, 29 days after assignment is given.
No. Under the Income Tax Act, what is the last date of
Last date, my
submitting
lord,
a-
I say October, my lord, so far. This is
October.
October, my
Okay.
lord, of the fund.
Okay.
Well, extra copy may be served.
No, extra copy. I say that. Extra copy in course of the day.
Obliged.
Production list item 2 WPC 3511/2024.
Yes, Mr. Sayavara, he has a grievance.
My lord, they say that there's some confusion, my lord. I do not know, my lord. Actually, we wanted to move it yesterday. We filed it on the 10th and by 12 we have sent the mail, my lord. I do not know, there may be some confusion, my lord. I don't know. And
With your
my-
lordship permission, may lordship allow the law officer to assist me?
Yes.
NHS.
Yes, you have seen our last order. You have seen yesterday's order.
Oh, I have not actually the order was not uploaded. That's why I have not seen the order.
No, it's uploaded.
Uploaded.
It's uploaded. Yes.
But I have
uploaded.
gone through the.
Before leaving, I ensured that it was uploaded. I went yesterday
Yes,
after
sir.
uploading at
Yes,
almost 7 o'clock.
Yes.
At almost 7 o'clock, I was here. I ensured that everything is uploaded and then I left.
Time actually I
Yeah.
But I have gone through the order, lordship.
Now, what do you have to say?
Lordship, in this case, lordship, what happened? The petitioner has actually terminated with due process of law, lordship. In the termination notice, lordship, is clearly mentioned everything. And what happened, lordship? The petitioner was allotted the work for package 1, Srirampur Dhubri, page 7, lordship. Srirampur Dhubri section NH 12-127B. That was package 1. And he has progress was in that area is package 1 is only 10%. But 10%. And Lordship, we have to take
No, you see, you'll have to still answer that, the observation of the court. You see,
Lordship,
what has happened, you issue a tender
Lordship.
before termination. You do
Because,
everything and then you settle the tender first and then issue a termination letter later.
Lordship, what
And his tenure is to complete the work is 25.
no, complete the work is 25.
Yes,
Into
25. So therefore, what is the ground of
Because here progress was very poor, Lordship. Only 10% progress was there. That's
before
why we have
termination?
terminated
No,
him.
before termination, what is required to be done?
Lordship, we have the termination order itself. We have explained everything. That
Yes,
page 78, Lordship, mechanically.
yes.
77.
78. 78, Lordship, paragraph 4. Everywhere his failure is there in every Lordship. Every respecting.
No, as per the tender document,
Lordship.
what is the process in which you can terminate?
If we fail to
You
If to fail to, if
city project.
my Lordship, that termination.
That is at page 46, my lord. 40, 46, my lord.
no, Mrs. Have the letter complete, then you.
Yes, correct.
His statement.
It's 46.
Page 78.
I'm not-
We don't know because when you make me read the document, I really read it. You have referred to page 78.
78, Lordship. The paragraph 4, what is the original date of milestone 1, milestone 2, milestone 3, and milestone 4? According to schedule.
Just a moment. No, not that. You see, come to paragraph 3. You say that your land was handed over and then you say a total of 95% land was given.
Yes, land was
No.
given, Lordship.
95%.
95%. Land was given.
No, but 95% you see. Please try to understand. I don't know the project.
95.
I'm not a contractor. I don't know how the work happens. Now, instead of 100% land, if you give 95% land, and then say the target achieved 10% was not there.
Yes. Not as if till date, Lordship. That is
No, that's
there.
okay. But the land is still 95%.
Yes.
If you don't give 100%, how do you get a 100% result?
Oh, let him.
The process for UT. There is a process for extension of time.
There is a process of extension of time, Lordship. But while he should have go on
Extension of
progress,
time,
Lordship.
you see, I have not come across any proposition in the contract where for every milestone you will have to give extension of time.
Extension of time was given to him.
You have extension of time at the termination of contract or the end date of the contract. Then you ask for extension of time and then you extend the time.
No, he has not applied for paid for extension of time.
25 is not even come. We are in 24 right now. 24
No,
has not come. The question of applying for extension is not even germane.
When his construction pay, he could not complete the 10%.
You show from the contract
Yes.
that for every milestone, he'll have to seek an extension of time. We show that.
Yes.
Show that.
That achievement was in his paragraph 4.
No, that is okay.
Yes.
That is okay. But for every milestone, he'll have to take an extension of time. He'll have to show only that.
Yes. Contract given time total. Termination of contract is explained in Article 23.1.
20,
23.1,
23.1.
contact
Mr. Saivala, we don't have that.
Page 45, ma'am.
page 45.
45.
ধরা আছে, কিন্তু paragraph 38
If the project completed doesn't within the period is not a schedule.
মানে এইটা,
Yes, page 45, we are there.
yes. Paragraph E and F, Lordship. Contractor fails to proceed with the works in accordance with the provision of clause 10(1) and stops works or the maintenance for 30 days without reflecting the same in the current program, and such stoppage has not been authorized by the authorities engineer. Paragraph F, the project completion date does not occur within the period specified in Schedule J for the scheduled completion date or
So-
any extension thereof.
So, read F. It's not even right for you to terminate.
Moreover, the contractors fails to, paragraph G, to rectify the defect. Any defect, the non-rectification of which shall have a material.
Mrs. Bora, it's
adverse-
not even right. You see, your own clause you are reading, it shows that the completion date
Yes,
is referable to completion date. Completion date is February 2025.
14 to.
Whatever
25.
is the date, date I will not remember.
We can terminate him. If progress is very poor, then we can terminate him.
No, that is okay, but you started with by saying that he did not apply for extension of time. The query of the court is, if you have 4 milestones for completion of the project,
Yes,
does your contract agreement envisage prayer for extension of time for every milestone?
no, that is not the.
That is the
but
court query.
He can apply for extension of time,
No, it's okay. You see, I have got, Mrs. Bora,
Lordship.
I have got 3 months time. If I make a CAV, I have got 3 months time to give a judgment. Correct?
Lordship.
Now, a few days back in Mr. Saiwala's matter, I could not give a judgment in 3 months' time. So I have had the matter listed in the court for further hearing, and then I told him that we'll be delivering the judgment on the same day. So that is an extension of time. Correct? Now, please tell us, within 3 months' time, when I have to give a judgment, do I have to inform you that I would not be giving a judgment on 1st of the month or 2nd of the month or 3rd of the month or 30 days of the month? Do I have to tell the lawyers? I have got no duty. So question of having the matter listed, just to tell the advocates that within this 15 days I could not deliver, is not a requirement. I am giving a horrible example. But if I can correlate the example to myself, I can understand it better. On the last day of the last week of the court, the last functioning of the regular court, Mr. Saiwala's matter was there. I could not deliver judgment within 3 months' time. So therefore, I had the matter listed for a re-hearing. The second person in the court is Mr. Nayak sitting behind. There was an election matter. I could not give the judgment. I could not give the, no, don't stand up. I could not give the judgment because of the fact that there are 4 matters listed before the court bench, all election matters, where similar petitions were filed, almost reproduction of each one is reproduction of the other, and the order passed by the court was stayed by the Supreme Court. So therefore, with the stay, how could I give a judgment? So therefore, I had to seek extension of time. I am listing the matter time and again, because of the fact that the view of the court has been stayed by the Supreme Court of India. So therefore, I had no other way but to make listing of the matter for extension of time to give the judgment, because I could not give it in 3 months' time. So although my example is an horrible example, but the fact is that unless you show from the contract agreement that the milestone, for every milestone to be achieved during the currency of the contract, there must be an prayer for extension of time. We accept it.
Lordship, in the termination notice itself, paragraph C, it isn't clearly mentioned.
Paragraph 3.
C, Lordship. Article 23(1). Please,
Oh, acha. Just I'll have to go and come back at 2. We'll take it up at 2 again. some matter pending in my chamber. Mr. Salivar, you will resume at 2. Now, there's some urgent matter I have to take up in these chambers. Administrative matter. I have to-
Yes, yes.
This is Harika.
I'm waiting for unlisted lordship.
Oh, acha. Okay. At 2.
Indulgence lordship. In this case, lordship, he unlisted one matter for allowing him to appear in an interview. Lordship, the interview has already been over, but I kept the interview expert member in the APSC in hope that any order may be passed this honorable court. If lordship can please to take up this matter, I can instruct that APSC to take the interview of his petitioner. Mechanical engineer. Today, that only one candidate in the special interview board has been constituted. And they are waiting for any order passed by this court. Lordship. 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 Obliged. No, Lordship, I'll communicate. Lordship, on last of, yesterday also Lordship on passed in the similar direction.
That order is at page 89. We have annexed the order. Yes, okay.
Lordship.
Yes.
Production list item 1, WBC 3508/2024.
Lordship. Petitioner, I have filed an additional affidavit, Your Lordship, as per order passed, Your Lordship, yesterday. And in this additional affidavit, I have stated that you mentioned yesterday, and I am agree with that. And so my humble submission is that
As per notification, they can run, madam, but subject to the clearance of the earlier dues, madam, if any, madam.
Lordship. S. Hussein, Lordship. Lordship.
All the response. Yes.
Existing lessons.
For the last financial year, Panchayat year, madam.
Kayakusi Hat. Kayakusi Hat. Lordship.
29, 6, 20.
Yes.
2 weeks, my lord. Monday deliver extra copy.
As an interim measure, the court is inclined to stay the operation of the order number, so and so, page, last page 35, dated 36/2024, issued by the executive officer, Paka Bedbari, PAKA BETBRI, Anchalik Panchayat, insofar as Kayakushi Hat, KYAKUCHI Hat, is concerned. Full stop. It will be stop resultantly, comma, it will be open to the concerned responding authorities to entertain the representation of the petitioner for extension of the lease of the Kayakushi Hat for a further period till the tender process of the said hut is finalized. Full stop. Next, liberty is given to the respondents to seek modification of the interim order, is to advise on. Next para, list on 31/7/2024.
Daily list item 7, time being.
Deeply obliged.
Yes, Mr. Budhokai.
Lordship, your lordship have put a query, your lordship, regarding the pleadings not available in the WS, your lordship. I'd like to draw your lordship attention to page 26, your lordship.
26.
Lordship, paragraph 16.
Yes.
Last part, your lordship, the contents of the said notice, your lordship.
Yes.
The contents of the said notice are all false, and the defendants has replied to the notice, said notice in detail, and called off the falsity of the plaintiff. And to avoid repetition, the defendant refrains from reproducing the contents of the said reply here, and prays to treat the copy of the reply of the said notice dated so and so as part of the written statement, your lordship. As because this point was there in the written statement, your lordship, so elaborately the reference of the said three rent agreements are not there, your lordship.
Okay. So you proved that giving you time to respond was wrong decision of the bench.
No.
No. Okay. Head. Mr. H. Bura, go ahead and counsel for the petitioner. Next para. By filing this application under Article 226 of the Constitution of India, the petitioner has assailed the order dated 12/6/2024, passed by the learned civil judge within bracket junior division number 2. Where? Dibrugarh. In TS number 134 of 2021, thereby rejecting the application of the petitioner registered as petition number 624 of 2024 under order 6/17 CPC, as well as petition number 625 of 2024 for keeping in abeyance the further proceedings of the said suit. Next paragraph. The petitioner is the defendant in eviction suit being registered, which was registered as TS number 134 of 2021 before the learned civil judge within bracket junior division number 2 Dibrugarh, and the petitioner has contested the said suit by filing a written statement. Full stop. During it is projected that during the pendency of the suit, the petitioner, in order to cross-examine the plaintiff's witness, had introduced the tenancy agreements dated 31/6/2017, 1/5/2018, 1/4/2019, 4 and 1/3/2020. Full stop. On the said agreements not being allowed to be used for cross-examination of the plaintiff's witness, the petitioner had approached this court by filing CRP IO 287 of 2022, and this court by order dated 29/11/2022 set aside the order dated 9/10/2022 passed by the learned trial court, and direction was issued for recalling of PW1 for further cross-examination on the purported tenancy agreements subject to payment of cost of rupees 5,000. Full stop. This page 39, who is the petitioner here?
It is the defendant, the petitioner, instant petitioner.
Petitioner defendant here. Okay. Full stop. This 280, this CRPI 287 order date is 29/11/2022. Full stop. Thereafter, by order dated 26/2/2024, the learned trial court allowed the petitioner herein, i.e., the defendant in the suit, to exhibit the set full rent agreements, tenancy agreements on payment of cost of rupees 2,000. Full stop. Next para. At this stage, comma, the respondent plaintiff raised an objection that the tenancy agreements were allowed to be, comma, which were allowed to be exhibited was not supported by any pleadings. Full stop. Thereafter, the petitioner filed an amendment application under orders 6 to 17, read with section 151 CPC on 12/6/2024 for amendment of the written statement to introduce the said four tenancy agreements. Full stop. The said application as well as the application for stay of the proceedings of suit was rejected by audit, impugn audit dated 12/6/2024. Full stop. Next paragraph. The learned counsel for the petitioner has submitted that in response to advocate's notice which paragraph?
Paragraph
Page
16, page 26, Lordship.
26. That in paragraph 16 of the written statement, by referring to the reply to notice dated 8/12/2020, comma, it has been stated that the defendant refrains, inverted commas, the defendant refrains from reproducing the contents of the said reply here and prays to treat the copy of the reply of the said notice dated 24/2/2021 as part of the written statement. Full stop, inverted comma, closed. Full stop. Accordingly, it is submitted that in the reply, and in reply to the notice of the plaintiff, comma, the petitioner dash defendant had referred to the earlier four tenancy agreements. Next paragraph. In view of issue notice returnable on 17/8/17, sorry, it will be 16/8/2024. The petitioner shall take steps for service of notice on the respondent by registered post with AD. Stop. In view of the contents of paragraph 16 of the written statement filed by the petitioner as defendant, the court is inclined to stay further proceedings of TS number 134 of 2021 pending for adjudication before the Court of Learned Civil Judge within bracket Junior Division number 2, Dibrugarh. Next one, list on so and so.
Deeply obliged.
Oh.
Time being item 15.
I made an effort to contact him, my lord, and I'm being told, my lord, he was on his way to the hospital for the checkup of his mother, my lord.
Okay. Heard Mr. P.K. Bunid, learned counsel for the petitioner, non-appeased and call for the respondents. By filing this writ petition in Article 226 of the Constitution of India, the petitioner has assailed the
Page 13.
his transfer order, her transfer order dated 1/7/2024 under number page 30, seal number 2.
30. Serial number 2.
Serial number 2, huh? By which the petitioner was transferred the petitioner who is holding the post of supervisor was transferred from the office of the CDPO, AMRI, ICDS project, Ullu Kunchi, ULUKUNCHI, West Karbi Anglong, to the office of the CDPO, RONGMONGVE. Next word is SAMELANGSO, ICDS project. Next word. Transfer is assailed on the ground that the petitioner is a specially able person with 45% disability in the limbs. And that the transfer is made during mid-academic session of for 2 minor children. So it is submitted that the husband of the petitioner is posted at
That is Kalyaville ME School.
where is that spelling?
I'm sorry.
Where is that spelling?
Page 28.
28.
Kalyaville.
At Kaliabil, KALIABIL, any school. As its headmaster.
And he resides there, but in the weekends he used to come to.
Okay, and the husband resides therefore resides in the said locality. In the locality of the said school. Stop. Issue notice returnable on. I'm looking at short date. Returnable on 24/7/2024. The learned counsel for the petitioner shall serve extra copies of the writ petition to the standing counsel for the Karbi Anglong Autonomous Council within 2 working days.
On Monday.
2 working days. Next, as an interim measure until the next returnable date. The transfer order of the petitioner bearing number so and so, dated so and so. Shall remain suspended. Next, list on so and so.
I'm deeply obliged.
Production list item 3 WPC 3524/24.
This is an eviction matter, lordship, where I have been threatened to be evicted. The whole number of petitions.
It is on a vacation day.
Yes, lordship, on vacation day. But there's a whole lot of them, lordship. It's a village altogether, village. From Karbi Anglong. Lordship, what?
Yes.
happened, the impugned order was issued on 20.
But the land is a PGR land.
It is not classified as a PGR land lordship, even though they claim, but in the records it's not there. And I have been residing there since 1964. In fact, in some cases, even pre-independence, we have been there. And steps were taken to regularize us, to settle them, make the settlement since 1970. But what has happened is that nothing had transpired, but finally an impugned order was passed on.
No, but even if even if the land is in the
Lordship?
in this area, which is what is that area? Karbi Anglong.
Karbi Anglong.
But still, once it is PGR or a VGR land,
Lordship,
there will be record of.
It's on record. It's not recorded as a PGR land loss. That's a funny. That is the strangest things. Even though they say time and again it has been said, but when they look at the records, it's not there. In fact, in the Chitta, my name is there. And Lordship, what has happened? And I've been there. My revenue, I have been paying revenue to the government, Tawji revenue, of course. Since 1963, I have annexed. And now Lordship and Lordship will find in that land, it's a fully established, almost a mini township where there are banks, there are schools, there's buildings, there are various. Lordship, I have given a list of the government institutions and facilities that's there in that area. There are as many as 45 different facilities which are there, including APDCL. Everything is there, Lordship, name it, an auditorium, everything has been set up there. It has, if it was ever a forest PGR land before 1963, that has it doesn't have resembled it anymore, Lordship. Since 63, we have been residing there. And the authorities because the authorities were giving us all these facilities, Lordship. I've given a list of them.
No, that's okay, but you see, Mrs. Adeka, we I'm not name the town for certain reasons because I have handled that determination. That's why. You see, there's a town within our jurisdiction, half of which is forest land. And now because of the TN Godavarman and the protection of VGR, there is another judgment in the Supreme Court.
Jagpal Singh, Lordship.
Huh?
Jagpal Singh.
Jagpal Singh.
Yes, but even Jagpal Singh gives me a protection, Lordship.
Okay, just show that.
I have
because of that judgment.
Yes.
Even in that town, we are now passing orders for eviction.
Yes, Lordship.
Because it's a reserve forest area, and therefore reserve forest area has a greater. We have held that it has a greater public interest.
But Lordship, there are more than 11,000 people staying there, and Jagpal Singh, I have quoted in page 34. Page 34 of my petition, Lordship.
Where is that? Give the citation, please.
Citation is Lordship 2011, 11 SCC, page 396. So in the last part, regularization should be permitted in exceptional cases. That's what it recognizes.
Just a moment.
And Lordship, after Jagpal Singh, the Disaster Management Department was also issued a notification following Jagpal Singh, where it made it very clear that new encroachers, that means who have come after January 2011, those should be evicted. Now, here is a case where I am residing since pre-independence, some of us, and we have even been issued pattas. Some of them have also been issued pattas, Lordship. And all this setup has been there. It's not that I am building a house and staying there, stray houses. No, it's not that, Lordship. The last bit, regularization should be permitted in exceptional cases where the lease has been granted under some government notification to landless or the members of scheduled castes or tribes, or there has already been school, dispensary, and other public utility on the land. We fall under that we have public schools, dispensaries, and other public utility. And all the government facilities have been there.
Have you given a chart of or any document where we can, from where we can have a bird's eye view of the petitioners and their status with regard to the land? Who is under a Tozi, who is under Pata, who is under the any other way of settlement?
Lordship, I have given the chittas.
Hmm?
The chitta is there, Lordship.
Where is that?
Lordship at page type 1 from page 51.
Page?
Page 51 of my report.
61.
51.
51. Okay. Fifty-one is government.
Yes. We are all Toji Lordship, actually. Repeat your. Huh? The page for 44, I have given my Toji receipts, Lordship. Huh? No, from 1965. If Lordship looks at page 44, it's from 1965. I've been paying Toji.
Yes. Ms. Andy.
It is done by the Tribunal Autonomous Council. The last note.
This is Harika.
Yes.
31.
Is the standing council informed of the matter being taken up today?
Yes, Lordship. He has been informed.
Be informed. Because you see, whether this is right or wrong, we don't know, but in page 52, which is the chitta,
Yes.
names of encroachers are already mentioned. I can't read the date,
Even I can't read the
22/7/88.
date. Lordship, it's too illegible. So whatever.
22/7/88, I think.
Well, Lordship, that was the date of giving copy of the chitta. The chitta was
Oh,
received.
copy.
Yes.
That is in 88, they're there. So give the interim protection. Not to evict till next date of listing. But the court would have no jurisdiction to pass orders at prayer number 4 of de-reservation of PGR.
Lord, that Lordship, I have prayed, but yes, I have prayed. I mean, no, I have no harm asking for more, Lordship. We are naturally greedy.
Okay. Take your word for it. Mrs. M. Hazarika, Learned Senior Counsel, assisted by Ms. S. Newar, Learned Counsel for the. How do you spell your surname?
NWAR.
ER. Then you have not paid your clerk well. You will find when you give you this, there's a this mentions this slip first order sheet. You find your name wrongly spelled. That means you are not paying your clerk well. Take care of them. Correct. Then counsel for the petitioners and Mr. J. Hendik, learned Standing Counsel for the Revenue Department,
1 and 2.
representing respondent numbers 1 and 2, and Mr. N. Goswami, learned Government Advocate, appearing for respondent number 3. So, none appears on call for. Next point. The learned Senior Counsel for the petitioner has submitted that the Standing Counsel for KAAC, representing respondent numbers 3 to 7, sorry, so it will be 4 to 7.
4 to 7.
4 to 7 was informed of the listing of the matter today. So none appears on call for the said respondents. Next paragraph. Where is that order 22, 2024?
That is lordship 129
129.
129.
and 120, sorry, 127.
127 losses.
The petitioners claim to have been in occupation of the government land for about 60 years.
Yes.
And and in this writ petition, filed under Article 226 of the Constitution of India, the petitioners have assailed order number, flag
Order
this
dated
page
20th February
page
2000.
127, flag is there, number so and so dated. What is the date?
22 2024.
2024.
Yes, sir.
Issued by the Principal Secretary, within bracket in charge, bracket closed, Karbi Angalam Autonomous Council. By which direction was issued to the Assistant Revenue Officer, Donika, DONIK, Revenue Circle, to take necessary steps for eviction of the unauthorized occupants. The next para, the Learned Senior Counsel for the petitioners has submitted that the petitioners have document to show their continued presence on their respective land for the last 60 years, which is either by way of entry in the Chitta and
Payment of charges.
also supported by payment of
Charges.
Revenue.
Revenue. Tozi Bahira. Tozi PUUZ Bahira. BHIRA. Revenue.
Stop. Which is that paragraph you have said how many institutions are there? Yes. You made some statement in your.
Yes, I made
paragraph.
the same.
Which is paragraph, which is that paragraph?
I'll just give. Page 26, Lordship.
26.
Page 26, para 10.
Referring to the statements made in paragraph 10 of the petition, I submitted that in the area in which eviction is sought for, there are 2008 numbers of households with a estimated population of 11,664 with 5 numbers of polling centers. And the description of the government institutions and public facilities on the said land are also described therein. Next paragraph. View of issue notice returnable in returnable on, make it 2/8/2024. So requisite extra copies of the repression be served on the learned state command. State Council, Departmental Council, and the Standing Council for the KAC within 2 working days. Next paragraph. As an interim measure until the next returnable date, it is provided that the conclusion of the impugn order number so and so dated 20/2/2024, this page 127, shall remain suspended in respect of the
Petitioners.
how many petitioners are here?
22.
And this will be 22 petitioners herein. You say only in respect of petitioners herein. Next paragraph, the petitioner shall serve.
Lordship, can it be on the 5th, Lordship, if it's not inconvenient?
Okay, 5th, make it 5th. Petitioner shall serve a certified copy of the order of this order to the principal secretary, KAC, in bracket respondent number
4.
respondent number 4, bring the order to the notice of the said authority.
Obliged.
Yes.
Obliged.
Time being item WBC 3511/2024.
Yes, Mrs. Bora.
Yes, Lordship, asked why the petitioner was terminated from the project.
Yes,
Lordship.
yes.
Page 84. Para 20.
Yes.
Before that, Lordship, I want to paragraph 19 also, that I want to that he seek time, Lordship, whereas MS page 84, para 19.
Yes.
Whereas MS Simplex Infrastructure Limited by its letter dated so and so has requested to hold a termination with the assurance to resolve all bottlenecks and accelerated the project. Hence, a meeting was convened on 15/5/24 under the chairmanship of Director Tender and NHIDCL, wherein the contractor committed to achieve the following targets by 31st of May 2024 to substantiate his assurance. It is observed that even after gaps of said committed date, that is 31/5/24, and the additional grace period till 11/6/2024, the contractor has failed to achieve his own commitment, that is given in the serial number 1 to 7, Lordship. After that, hence the authority is left with no option other than to proceed for termination of the contract in the wider interest of the road users. Paragraph 20, Lordship. Whereas it has become evident that that EPC contractor is not in a position to execute the contract with the provision of the contract agreement and continues to be in default of the obligations as brought out in the cure notice, leading to a major material adverse effect on the contract. Further, the EPC contractor has breached the contract agreement inter alia with the following defaults in terms of the clause 23.1, the article 23 of the contract agreement. Number 1. Subclause C, the contractor does not achieve the latest outstanding project milestone. 1. Due to accordance with the provisions of Schedule J, subject to any time extension and continues to be in default for 45 days. Subclause E, the contractor fails to proceed with the works in accordance with the provision of clause 10.1 or stops works and or the maintenance of for 30 days without reflecting the same in the current program, and such stoppage has not been authorized by the authority's engineer. Subclause 3, subclause Z, the contractor fails to rectify any defect and the non-rectification of which shall have a material adverse effect on the project within the time specified in this agreement or as directed by the authority's engineer. 4. Subclause P, the contractor has failed to fulfill any obligation for which the failure termination has been specified in this agreement. Or subclause 5. 5 subclause Q, the contractor commits a default in complying with any other provision of this agreement if such a default causes a material adverse effect on the project or on the authority. In view of the above mentioned facts and circumstances, non-exhaustive fundamental breach and the EP contractors present a substantial gross default in fulfilling contractual obligation, leading to a material adverse effect on the project, the authority is left with no other option but to terminate the contract with MS Simplex Infrastructure Limited in accordance with clause 23.1 of the contract agreement with immediate effect. That upon termination of contract on account of contract default under Article 23.1, the residual portion of provision of the contract agreement shall henceforth apply. This termination notice is issued without prejudice to any other right or remedy available with the authority under the contract agreement and the applicable law. This issues approval of the competent authority. That's why he's due to his failure in the contract agreement lordship, the termination notice was issued. Regarding the giving the allotment of 100% land lordship,
Yes.
regarding the allotment of 100% land lordship, it is not mandatory that they have to hand over the 100% land lordship because RO, the right of way, it is given 5% is given after 150 days. It is mentioned is in our contract agreement is paid on the appointed day lordship.
We have to give the 90% land.
We have to give the 90% landlordship.
Where is that?
But it is in the contract agreement. They have not annexed all the documents. Yes. Mark for it, yes. On the appointed land, we have to allot the 90% of land.
Remaining 10% after 150 days.
And remaining 10% after 150 days, lordship.
Where is that 150 days clause?
Clause Next page, Lordship, mark, round mark is, no, this page, round mark is there, Lordship,
No, that is for 90%.
90%.
Yes.
From the date of appointment date, Lordship, 90% land is allotted. And remaining 10% after 150 days. Six, seven,
No, that 150 days is where? Which clause
It is flagging, my lord.
is flagged?
Right.
Just check out. Yes.
Regarding extension of time, Lordship, that is also there, Lordship, the extension of time can be granted, Lordship, after completion of milestone 1, that is 10%. Achievement is 10%, but he has not achieved, he has achieved below 10%.
Where do I find that?
Schedule J, my lord.
Schedule?
J is mentioned in the flags, my lord.
Schedule
Schedule
J.
J.
Schedule J. Side.
So
Okay.
regarding
Schedule.
only one copy is there, that is problem.
Yes.
That is there, Lordship. EOT has to apply without affecting the project completion schedule, Lordship.
They have to define.
Yes.
If they fail to accept the project.
They have to achieve the project milestone,
If they
Lordship.
fail, they have to
If he failed after the project milestone, then authority has the power to terminate. He has failed to achieve 10%. He has achieved on below 10%. This authority has power to terminate him.
As on 28 April, he was supposed to achieve 35%. As on 28,
As on 28/4/2024,
he was supposed
he was supposed to achieve 35%. Page
20
78.
28.
78, Lordship. It has
Page-
been, as on 28/4/24, he has to receive, supposed to receive 35%. Page 78, Lordship, it has been mentioned. In the recipient date, no receipt till date. Similarly situated project, nearby project, he has completed 75% of the work. Or he has, but below 10% he has completed. That's the problem, Lordship, because we have to take, we have to take loan from the JICA, Lordship. So if we do not complete the project within a time period, then you have to pay the interest to the loan. We have, this is a government authority law. That is the problem. So we have waited for a long time, Lordship. So, we have no alternative that terminate him. But you have to hand over
No,
the project
you
to some
see-
other contractor, Lordship.
You see, that's okay. But that was not the query of the court. The query is that how could you issue tenders and all everything before termination? The termination, the termination took place subsequently. The tenders and all were floated earlier, and that is risk and cost.
That is reason because we can.
So how could you do that?
Because tender process, it takes a long time. It takes us some time. Our works has to be done before the rainy season. So we have, the process was started, Lordship. But we have not finalized. We have not given the tender to anybody else. But how can these people like this contractor, how he can be allowed to actually to do all these jobs? Lordship knows whether Lordship has seen the Poliabor, that bridge flyover. Since 2017, this contractor has not completed till date. It is hanging like this, Lordship. Same contractor.
Last 6 months, I see only 1%.
Only 1% achievement is there. That Poliabor.
No, that we don't know, because you see, you are the employer. You have employed them. How much work is suitable to you, how much work is not, it is for you to decide.
Yes, performance is very poor. Progress is very poor. That's why, Lordship, we don't want to actually keep like this contractor to go ahead with our construction work. Which urgency is there, Lordship, because people will suffer if the construction work is not properly done, Lordship. Ideally, he is doing leisurely the whole construction work, Lordship, of his own. Even the intention to termination notice was also served to him. And that is paragraph 81, it is late. And the paragraph 81, 16 paragraph. The intention to termination notice was served to the EPC contractor on 26/12/23. In accordance clause so and so, the contract agreement listing all the grounds of intention to termination notice due to inadequate mobilization in terms of manpower, equipment, and machineries on site, and contractors' lack of ability to achieve the progress in working season, Lordship. By the intention to termination notice dated 26/12/23, 15 days time period was granted from the date of issue of this notice, else action as per the provision of the contract agreement was to be taken. Paragraph 7, where is the EPC contractor replied to the intention to termination notice by letter dated 9/1/24. In this regard, PMU Dhubri so and so NSA has conducted a site visit on 13/1/24, along with the project manager of EPC contractor to examine the references and explanation of EPC contractor. In this regard, the observation of the NHI DCL is here in below. The observation of the LN below, Lordship, that everything has been mentioned from clause serial number 1 to 4.
But please tell us. See, even if we accept your contention that you initiated the tender process
Before
way
it
in
started.
advance, way in advance, correct?
But it is a risk and cost. Correct?
Not recent cost, Lordship, we only, you can, under the contractor, tender was floated for the balance work, Lordship,
Only balance work,
Balance
not
work.
risk and cost.
not recent cost.
Now, if you this balance, unless you terminate and have the measurement taken, how do you calculate the balance
Measurement,
work?
Lordship, measurement is taken after the termination of the contract. Measurement is taken, Lordship. After the termination of
Where
the.
is that?
You put something. It's mentioned in the contract agreement, Lordship.
It shows that because
Article 23. 22 has said? 23. Something, both sides, any other thing. Yeah. Any complete the work, any other to do the authority, this is no issue, matrix.
23. My lord, they have not enclosed the complete
This-
contract agreement.
This page is not
Selectively
enclosed in the spirit. This is a problem.
Yes.
Next page is not available.
that's it. It is there.
Only some few pages they have annex. Ah, 23.
That's it. Logan.
23.5.
Anything else, Mrs. Bora?
You will file affidavit also. We have to file.
Yes, Mrs. Haiwala.
Tender process is state lordship, then we'll suffer lordship there.
Well, first thing, they had floated a tender, they say balance work for the widening. How they can find a balance work, my lord, in March, my lord? When the contract was terminated in June, my lord.
That will calculate.
They say that they're taking measurement after termination of the work. Then after termination of the work, only measurement can be taken. How they can say balance work and how the tender can submit tender when work was going on during that period? Even on 22nd of May 24, my lord, yesterday I have shown my lord base 68. They have appointed the authority, my lord, the consultant. And we are asked to, my lord, approach him for that purpose. This is absolutely arbitrary, my lord. The latest one has said, my
Authority
lord.
engineer is
Just
appointed.
let me complete.
Yes,
Let me complete.
sorry.
So, tender has been said balance work. I do not understand how balance work can be given. How tender can submit tender, my lord, balance work. When they have measured. They say measurement will be taken after the termination. Naturally, after termination only measurement can be taken. And
If the earlier notice, my lord, that they have to take steps within 15 days as per the contract, my lord. No steps have been taken. We are allowed to continue with the work. Then they have to issue another notice, my lord. Intention of termination. 15 days, given current 15 days time. How they can terminate?
Where you are referring this 15 days notice?
My lord, that is at 23.2, page 46, my lord. That was given in subclause 2. Without prejudice to any other right, the remedies authority shall have under this agreement upon occurrence of the contractual default, the authority shall that will terminate the agreement by issuing termination notice the contractor, whether before issuing termination notice, the authority shall by notice inform the contractor of his intention to issue notice such termination notice and grant 15 days time to contractor to make a repayment and may after expiry of the 15 days, whether not it is receipt of such repayment issued cancel. This is nothing I can follow my here.
Yes.
Well, my humble submission, my lord, that when they are going to measure it, my lord, after termination, the question of issuing tender, my lord, in advance does not arise, my lord, for the balance works. My lord, at page 46, Roman 4, my lord, if you also see, page 4.
Yes.
After termination of the agreement, the contractor default, the authority may complete the work arrangement for any other entity to do so. The authority and to entitled to use the materials, plant, equipment, contractor's document, and other design documents made by on behalf of the contractor. Well, everything, my lord, they want to take, my lord. Now they have issued the notice, they will take over everything, my lord, of the contractor. Let them file the affidavit, my lord, that your lordship may decide. Humble submission, my lord, that absolutely arbitrary action has been taken by them. The latest judgment, my lord, that MP power management, my lord, say that arbitrary action, my lord, will.
What is the citation?
My lord, that is 23-2 SCC 703. My lord, I can just give a copy also. 703, my lord. My lord, there are several paragraphs, 73 to 75 arbitrary action they have defined. Now 190 to 193, my lord, at page 796, your losses may take.
Yes.
There is another aspect of matter, the termination of a contract undoubtedly results in intrusion into the repression of valuable rights which are vouchsafed to be awardee of the contract. It would be argued that before the contractual provision, unless be it the contract peremptorily provides for termination of the contract, especially without service of notice on the occurrence of certain events, principle of justice may not be out of place under the theory of fair action. Also, Article 14, opportunity to the awardee as to why the contract should not terminate may be must. It may be added that in every case in which citizens knock the door, the court breach of a fundamental right is a matter contains public elements as opposed to a case only breach of contract and damages flowing therefrom, but a breach of this natural justice, no doubt, is such plea be found sustainable, sounds in constitutional law as arbitrary state action, which attacks provision of Article 14 of the Constitution. Well, here, absolutely, it is arbitrary, my lord, on the face of it.
Even my lord, that 100% your losses acts, that is also not given even after 6 months. If your losses see at page 78, even after 6 months also 100% has not been given. This is para 3.
No, that is your default.
My lord?
That is your default, not achieved till date.
No, no,
That
no.
means your
That is
maximum.
correct. Not land, my lord. Free land.
Oh,
Where is
acha.
3, para 3. Last line. As per joint memorandum, total 90 so-and-so industry land was handed over to contractor by revised joint memorandum dated 38/23. After 6.5 months, my lord, they have given 95%. Not 100%. They say after 150 days, they will give 100%. Nothing. Many other posts are there, my lord. I am not for that, my lord. Only I am the measure, my lord. We think that how they can issue a tender in advance, my lord, before termination of my contract. When as per the contract, also, my lord, they can do the balance work only after termination. Balance work cannot be shown in the tender, my lord, before termination. In the file the affidavit early also, your notice can given the date also. I have nothing to say.
Here it would be 95%.
Okay, examine and pass orders. Yes.
One last submission is there, Lordship, regarding jurisdiction point. Article 27.1, the jurisdiction is in Delhi, Lordship. In the contract agreement, Lordship.
Contract agreement,
Yes,
this one.
Yes, 27.1.
27.1.
Okay, let me examine.
Yes, yes, yes. Yes. Huh? Oh,
Yes, my lord. That is.
two, three. Five.
1, 2, 3, 4, 6.
Oh, clearly, we're not going.
1, 2, 3, 4.
লিখে দিবি নামটো কনফিউজন লাগিছে তো নামটো লিখি দিছে আজি চাহ খোৱালে বুলি লিখে দেই নহ'লে খতম কৰিলেও লৈ যা লৈ যা লৈ যা অ অ বাঢ়ি আছে হয় নেকি সেইটো আহিব নালাগে অ নালাগে টুকিলে থব মোৰ চব বন্ধ হৈ গ'ল
live stream to upload. 8 1